Court calls the case of the People versus Alexis Brown.
Good morning, Assistant Public Defender Lauren Perry on behalf, well, not on behalf of Ms. Brown. We are the attorney of record on this case. When I did meet with Ms. Brown, she informed me she wants to represent herself.
Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
All right. So, in this matter, Brown, I do have to inform you that the complaint in this case alleges that on or about June 8, 2024, at the location of 3001 Woodland Hills Drive in Pittsfield, Washington County, State of Michigan, that you did commit the offense of assault and or assault and battery against a Latasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor, punishable by 93 days in jail, $500 fine plus court costs. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation, in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney.
Mm-hmm.
The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that counts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time you
I served 30 days already.
And if you serve 30 days, it may count. I'm trying to look at what your bond is on this case. What do you have a bond?
And then no contact with the victim as well.
And the monetary amount? 5,000, 10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't told your rights when you arrested me? Well, not you, but the officer?
I cannot.
You can't do nothing about it right now?
All
right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay.
Stated.
It's on record, right?
On May 19th, 2025, the clock officially started ticking for 33-year-old Alexis Brown. Prosecutors in Michigan's 14A District Court, Washington County, filed criminal assault charges against her, serious allegations that demanded her appearance before a judge. Her arraignment and pretrial hearing were set for June 18th. It was her first opportunity to address the charges. But when that day arrived, the courtroom doors opened and she never walked through them. The court responded the only way it could, by scheduling a show cause hearing for July 2nd, giving her another chance to explain her absence. Once again, she failed to appear. At that point, patience ran out. A warrant was issued. Law enforcement eventually located her, and on July 14th, 2025, she stood before the court, this time in custody. Probable cause was established at her arraignment, and because bond had not been secured, she remained behind bars. 3 days later, the Washington County Office of the Public Defender formally entered the case. Assistant Public Defender Lauren Perry was present and prepared to represent her. But in a move that would dramatically shift the direction of this case, Ms. Brown refused the assistance of counsel. Instead, she chose to represent herself, and as we're about to see, that decision changed everything.
So,
okay.
What do you want this set for, ma'am?
Your Honor, we have no offer at this time.
Do you want it set for a trial, ma'am?
Sure, I guess. I guess.
You want a jury trial or a non-jury trial?
It doesn't really matter.
Well, you've got to make a decision, ma'am.
If it gotta go to trial, then it gotta go to trial.
Okay. Do you want a jury trial or a non-jury trial?
It doesn't matter.
You have to make a decision, ma'am.
It could have a jury. Fine. That's fine with me.
At one point, Ms. Brown asks the question you hear all the time in courtrooms and traffic stops. Was my arrest illegal because I wasn't read my rights? It's a common belief and a common misunderstanding. Judge Simpson immediately makes it clear that he can't answer that for her. And here's why. Contrary to what movies and viral videos suggest, an arrest does not automatically become unlawful just because officers don't recite Miranda warnings on the spot. That's not what the law says. Back in 1966, the United States Supreme Court decided Miranda versus Arizona. What that case actually established was far more specific. Police are required to advise a suspect of their right to remain silent and their right to an attorney before conducting a custodial interrogation, meaning questioning someone while they're in custody. If officers fail to give those warnings, the remedy isn't that the arrest disappears. The arrest can still be perfectly valid. What may be excluded are statements made during that unwarned custodial interrogation. In other words, certain statements could be suppressed and kept out of evidence later. That's the consequence, not automatic dismissal. But here's where it gets more interesting. Even if Ms. Brown misunderstood the law, Judge Simpson couldn't step in and correct her in a way that gave legal advice. Under Canon 3 of the Michigan Code of Judicial Conduct, judges are required to remain impartial and avoid even the appearance of bias. They can help self-represented litigants understand procedure and ensure they have a fair opportunity to be heard. What they cannot do is act as their lawyer. Here's a line, and it's a firm one, explaining courtroom process. Allowed, providing substantive legal strategy or advice. Absolutely not. If Judge Simpson had walked her through how Miranda actually works and how it might apply to her situation, he would have crossed into advisory territory, a role reserved strictly for attorneys. And once a judge starts giving one-side legal guidance, neutrality is compromise. SO when he declines to answer. It's not avoidance. It's discipline. It's the boundary that keeps the courtroom fair. And in cases like this, that boundary matters more than most people realize.
Jury final settlement conference in this matter will be set for 17th, 2025 at 9 a.m. Jury selection in this matter, October 20th, 2025 at 8:30. Both of those proceedings are in person. Thank you.
So am I free to go? So why am I not free to go? If she just said she ain't got a bond.
Pardon?
Why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Cause you just asked her the same thing. Cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
And you can go post bond.
Okay, thank you.
It's your fault, parenting. Your fault. You just like suckered me into that. You got up there and then just said, well, we're the attorney of record, but
Oh, we're starting off the morning with a series of bad decisions already. This is wonderful.
yeah, I know, but they're all by Kearney. The whole McDonald's thing, and then this. And okay, let's try this one.
At this stage, Judge Simpson turns to an important decision, one only Ms. Brown can make. Does she want a jury trial, or does she want the judge alone to decide her case? That choice isn't just procedural, it's constitutional. Back in 1968, the United States Supreme Court ruled in Duncan v. Louisiana that the Sixth Amendment guarantees criminal defendants the right to a jury trial in what are considered serious criminal cases. Then, in 1970, Baldwin v. New York clarified what serious means. Generally, if the possible sentence exceeds 6 months in jail, the defendant is entitled to a jury under the federal Constitution. Now here's where it gets interesting. Brown is charged with a 93-day misdemeanor. Under the federal standard alone, that would not automatically trigger a constitutional right to a jury trial, but Michigan law goes further. Article 1, Section 20 of the Michigan Constitution provides a broader protection. It guarantees the right to a jury trial in every criminal prosecution, even those punishable by less than 6 months. That means Ms. Brown does have the right to request a jury under state law. However, having the right and exercising the right are two different things. Under Michigan Compiled Law Section 763.3, a defendant can voluntarily waive a jury trial and choose what's called a bench trial, where the judge acts as the fact finder instead. But that waiver has to come from the defendant personally. It's not something the judge can decide for her, and it's not something an attorney can impose without her consent. So when Judge Simpson asks her to make that choice, he isn't pushing her in either direction. He's fulfilling a legal requirement, and in the end, Ms. Brown chooses to exercise her right to a jury trial, setting the stage for this case to move forward in front of 12 members of the community instead of one judge.
Carson, you can remove your hat. This is the court proceeding. Today was the date scheduled for a discovery or a debtor's examination. Were you able to complete your exam?
No, Your Honor. Mr. Carson refused to answer any of my questions. He said he's not going to play games with me.
What games are being played, Mr. Carson?
Well, Your Honor, when I was previously there, I received a verdict by you that I believe to be emotionally charged due to your frustration with my inability to complete the tasks of a lawyer. I attempted to get a lawyer through the system. They denied me. I had to show up last minute unprepared, and things didn't go my way. So I figured, I'll do the process. I'll try to appeal it. I go downstairs and I'm told I have to pay $200 and some to even have a chance to get a fair trial or verdict. I'm having one individual who was emotionally charged at the time decide what has to happen with me instead of a jury of my peers. And now I'm being told I have to produce all my financial statements, documents, vehicles, titles, all this. And I have no interest, time, or energy to continue this charade. I've lost several days of labor.
Let me stop you because I'm just getting updated on this case. This was a landlord-tenant hearing that I presided over. Did you demand a jury trial?
I'm sorry?
Did you make a demand for jury trial in the landlord-tenant?
I requested, yes.
You was there a demand on
in written? I didn't put anything in writing. I did request the trial. I went downstairs and asked what my rights are, and they said to proceed any further past your decision, I had to pay $200 and some to even try. I did not have the money at the time, nor would I have it.
But sir, I asked you to let me get caught up. I'm trying to see if you have filed a jury demand. Let me also be clear. I don't make decisions because I'm emotionally charged.
No,
don't talk over me. Don't talk over me. Just because I won't let you run my courtroom does not mean that I am emotionally charged. There's order that will be set in the courtroom, and you will not talk over people. You will present the evidence. I'm absolutely fair and impartial, and you then have the right to appeal my decision. Just because you disagree with the decision doesn't make it impartial, okay? And if you don't follow, there's rules in place that I don't set as to how you file such appeal. If the clerk's office told you what you needed to file to move forward with the appeal, then that's what you needed to do. But I'm going to make it clear on my record that I did not make a decision in this case based on any emotions. I have no reason to be emotional about your eviction, sir. I'm not being evicted. So if you keep talking over me, this is probably what you did the last time. It's try to cut me off. Yeah, and you're shaking your head. So that's not me being emotionally charged. That's me not allowing you to run my courtroom. You don't talk over people. You have a question.
Yes, I was just speaking and you cut me off, but I'll let I
run the courtroom.
Okay, I understand.
Did you notice that?
May I finish, Your Honor, please?
Yes.
Okay. At the time of the last proceeding, I interrupted you. I apologize. But the second or third interruption, you stopped me in the middle of my sentence and awarded them the decision. You know what? You were like, you know what? Decision for them. You didn't specify why. It was just an emotionally charged because you were frustrated with my inability to complete the tasks of a paid lawyer.
I have evictions every single week, and the majority of my evictions are people who do not have attorneys. I don't know if you know that. Over 75% of our cases do not have attorneys representing them. I do not get frustrated with your inability to do the task of a lawyer. Where I will get frustrated and where I will not tolerate is if you think you're going to yell out or yell at the other party, yell at me, and you're going to act a fool in the courtroom, I will no longer allow you to be heard. Just because I cut you off and make a ruling does not mean that I ruled in their favor because I was frustrated with you. I was going to rule in their favor anyways because of the facts of the case. I was allowing you an opportunity to be heard. But when your opportunity to be heard becomes a hindrance to the procedure in the courtroom, then I have to terminate the hearing. And so if you want to proceed in any other manner, I don't know what your rights are now at this point as it relates to your right to appeal. You may have exhausted that time frame, but you're going to need to appear in person. I'm going to reset this since you refuse to comply with the court order to participate with the discovery proceeding. Because this is an official proceeding. This is not your option. You have to participate in the proceeding because you have a judgment against you and the plaintiff has the right to figure out how they can recover on that judgment.
Can we
Do
speak?
you understand that? Yes, you may.
Well, we tried to tell her, like, the funds, we can pay them. Like, we have no problem with that. We tried to tell her the same thing.
What is the past due amount?
It's roughly somewhere in the ballpark of $10,000 with interest, Your Honor.
And you're
I asked him if they could make a payment in full, and he wanted to argue the merits of the judgment itself. I never heard an indication there would be a payment in full. If there's some sort of payment plan, I'm happy to discuss that once I get my questions answered, because they have made no efforts to make payment on this, never reached out. We've tried multiple different avenues for the information that we did have on where we thought they banked and where we thought they worked. So I would need answers to all of the debtor's exam questions, and then I'm happy to work out a payment plan. In the event of a default, then I can pursue other arrangements.
okay. Are you in a position to pay in full the past due amount?
I'd prefer a payment plan. I would like to see what the interest is and what the original charges are. I was never actually formally presented with any numbers, despite what she had just told you. Until we were physically served for this court date, I had heard nothing other than a couple of emails where they were denied requests to garnish.
Yeah, we haven't received.
That is literally the only thing pertaining to the case I have seen since I walked out of your courtroom, attempted to file for an appeal, and was told I had to physically come up with money to do so that I didn't have at the time. So I at no point was ever given a fair trial. I was given an opportunity to pay for one potentially, but I've received, like, the judgment is for, you gave them and rewarded them things they shouldn't have had. We weren't there. Like,
If you disagree with the court's position, you have the right to appeal. You failed to do that. I also want to correct the record again. You did not properly file any demand for jury trial, although being advised on your first appearance of how you have the right to a trial and how to file such jury trial demand. You did not file a jury trial demand. So if you didn't get a trial, that was on you.
As of the time this episode was put together, Ms. Brown's case is still pending. A final settlement conference is set for October 17th, 2025, with jury selection scheduled to begin on October 20th. Court records show that, so far, there haven't been any additional adjournments. In other words, this case is still very much alive and heading toward trial unless something changes. Now, shifting gears to the second proceeding featured in today's episode. This hearing took place in the courtroom of Judge Kristen D. Simmons in Michigan's 54A District Court in Lansing. Earlier in the year, on February 20th, 2025, Judge Simmons entered a judgment of eviction against tenants Chase Carson and Amanda Wilson. In addition to regaining possession of the property, the court ordered them to pay their former landlord $9,898 in damages, but a judgment on paper doesn't automatically mean money in hand. MR. Carson and Ms. Wilson did not satisfy the judgment. As a result, the landlord's attorney, Jessica Larson, attempted to collect by pursuing wage and bank garnishments. Those efforts, however, hit a wall. Without updated employment or banking information, collection attempts largely stalled. SO, the landlord turned to another legal tool. On August 19th, 2025, the court scheduled what's known as a debtor's examination, a court-ordered proceeding where the judgment creditor has the right to question the debtor under oath about income, assets, employment, and bank accounts. The goal is simple: uncover the information necessary to enforce the judgment, and this particular debtor's exam was set to take place virtually, adding another layer to what was already shaping up to be a tense proceeding.
Well, then I guess I misunderstood. That goes back to me not being a lawyer and wishing that I had.
That does not go back to you being a lawyer. We made a video. We make a virtual presentation. It's a video that I play, and every courtroom in this court plays that video at the first appearance. Most of you all don't pay attention to the video. It tells you very clearly in very plain language. You have the right to a jury trial. And you can make such demand for a jury trial, and it tells you how to do that. You don't need to be an attorney to do that.
Sorry, go ahead.
I'm done.
Can she produce an actual number, or are we going off of what she thinks?
I'm asking for what's in the judgment plus whatever interest is, and I haven't calculated it.
You wouldn't have calculated that before today?
You can do one of two things, sir, because I'm not the games that are being played, I do not believe are on the part of the plaintiff at this point. You can participate in good faith right now in the debtor's examination, provide the answers to the questions, which are under subpoena. You've been ordered to court for this purpose. Or I can reset this and order you to appear in person. If you fail to do that and to comply, then we have to proceed to a next step, which is a bench warrant. And I don't think you want a bench warrant over a civil matter. So it's in your best interest to comply. It sounds like she's willing to work with an installment payment order, but only after she gets the answers that she needs to figure out how they're going to recover on this debt. So how do you want to proceed?
I'm sorry, Your Honor.
I'm sorry.
I asked him if he had any of the documents there were, in addition to information, the documents, plenty of documents that were asked for, and he indicated that he wasn't going to produce those. So I would ask him to appear in person with all of the documents.
Oh.
And I'd also ask that, Your Honor, that he return to a tone that is respectful. He has screamed expletives at me the last time we were here in court, and he's called me things today. And it's uncalled for and unnecessary.
I am absolutely clear that the emotional charging was not from the courtroom. I'm not going to allow you to berate anyone in this courtroom, nor will you disrespect me or the process. You can appear in person. I'm going to reset this date. You need to bring the documents that were ordered under the subpoena. If you fail to comply, the court will issue a bench warrant.
Your Honor, save yourself the time. Have her fax.
Don't tell me what to do. Don't tell me what to say. You instruct yourself.
I'll pay her in full.
You instruct yourself, or you'll be in contempt of court. Okay?
Excuse me?
You control your own mouth. Don't tell me what to say. I've already given you an opportunity.
Your
I'm
Honor.
now resetting this. You can appear in person. If you pay in full, then they can move forward to make sure that this removes off of my docket. But do not tell me what to do. I do not tolerate your tone. This is how we got here the last time. That might work with the lady sitting next to you, but you don't talk to me like that. Not in the court, not outside the court. Do you understand that?
I'll pay the balance.
Thank you.
My phone number is on all of the court paperwork. You can give me a call and I'll give you a number.
Give me a new date.
September 4th at 1:30.
September 4th at 1:30, you said? Yes, in person at the court. If you pays in full, you can provide evidence of that and have this removed from my docket. Any additional matters for the record?
No, Your Honor. Thank you very much.
Save the
You're all
tax
set.
and money.
Mute him and remove him from my courtroom before he's in contempt. Mute him and remove him from my courtroom before he's in contempt.
During the hearing, Judge Simmons makes something very clear to Mr. Carson. If he wanted to challenge the original eviction ruling, the time to do that is already passed. The proper route would have been filing an appeal or a post-judgment motion, not trying to relitigate the case during a debtor's exam. Under Michigan Court Rule 4.201, Once a judgment is entered in an eviction case, a tenant has a very short window to act. Generally, that means filing an appeal or appropriate motion within 10 days. Miss that deadline and the judgment becomes final. Filing an appeal isn't just about paperwork, either. There's typically a filing fee involved, covering the administrative costs of processing the appeal, updating court records, and scheduling further proceedings. That's likely the $200-something Mr. Carson mentioned earlier in frustration. But whether the fee felt burdensome or not, the rule still applies, because neither Mr. Carson nor Ms. Wilson filed an appeal or post-judgment motion within that required timeframe. They forfeited their opportunity to challenge the eviction ruling. The judgment stood. The same concept applies to the issue of a jury trial. Rule 4.201 also makes it clear that if a tenant wants a jury trial in an eviction case, they must demand it either orally at their first court appearance or in writing within 5 days after being advised of that right. It's not automatic. It has to be properly requested. Since no timely jury demand was made, that right was waived as well. By the time this debtor's exam rolled around, the legal arguments about the eviction itself weren't up for debate anymore. The case had already crossed the finish line. What remained was enforcement, not reconsideration. Part 6. Judge Simmons ultimately reset the debtor's exam for September 4th, 2025, ordering Mr. Carson and Ms. Wilson to appear in person and bring the financial records requested by Ms. Larson. But before that hearing could even take place, court records show something changed. A certificate of satisfied judgment was filed, indicating the debt had been paid in full. So in the end, compliance came, just later than it should have. Taken together, these two proceedings highlight something we see time and time again: the real risks of self-representation. In Ms. Brown's case, she struggled to understand the purpose of the hearing and appeared to believe her arrest was automatically unlawful because she wasn't read her Miranda rights. But Miranda doesn't invalidate an arrest. It limits the use of statements made during custodial interrogation. That distinction matters. And while Judge Simpson could clarify procedure, he could not step into the role of legal advisor without compromising his neutrality. An attorney, however, could have evaluated whether any questioning qualified as custodial, explained how Miranda actually applies, and, if appropriate, filed a motion to suppress certain statements in Mr. Carson and Ms. Wilson's situation. Particularly Mr. Carson's, the issue wasn't constitutional misunderstanding. It was procedural missteps. He appeared unfamiliar with how to properly challenge a judgment, the deadlines for filing an appeal, and when a jury demand must be made. By the time he tried to argue the merits, those doors had already closed. An experienced attorney could have ensured deadlines were met, rights were preserved, and arguments were raised at the correct stage of the process. The broader lesson here is simple but important. Courtroom rules are technical. Deadlines are strict. Remedies are procedural. And judges, no matter how patient, cannot serve as legal counsel. Going it alone dramatically increases the risk of missed opportunities, forfeited rights, and asking questions the court simply isn't allowed to answer. If there's a case or courtroom exchange you'd like us to break down next, drop it in the comments below. Thanks for watching, and if you found this helpful, consider subscribing and sharing so we can continue building a more informed community.